Good morning. I'm Father X, talking about how fathers can win their child custody case. In this episode, we're going to talk about managing the pros and cons of a long child custody trial so that you can plan ahead. Let's get to it. Why does this matter? A divorce and child custody trial is extremely stressful for both parents. It's easy to be overwhelmed by the emotions and lose sight of what's really happening here. I want you to be eyes wide open as to what you're facing. Take advantage of the opportunities of a long trial process and minimize the damage from the disadvantages of this long process. So today, we'll discuss the opportunities, the disadvantages, and some tactical strategies you can use. I know the family court process seems hopeless. I felt the exact same way, but I took advantage of some of these factors to save my son from the standard process that rubber stamps the mother. First, a longer trial process gives you more time to do the absolutely necessary research to understand the law and how the court process works. You also have time to review case law on Google Scholar, which is different than plain Google search. On Google Scholar, you can search for appellate cases in your state and look up cases related to the best interests of the child. Read at least 50 cases. They're short and easy to read. This is an important step in undermining the gender bias and incompetence of your family court judge. If the entire child custody process took only 2 to 4 weeks, then you would never have the time to learn the laws, to identify when your judge is violating those laws. Second, prepare your evidence for trial as soon as possible. This includes accumulating all those emails and text messages, police reports, and educational records, etc. Your internal goal for this evidence is to prove that you're 5 times a better parent than she is, so that a biased judge might look at you as an equal parent. You'll also need evidence to undermine the mother's false allegations, if any. Make sure that your evidence and testimony are centered around the best interests of the child, as I discussed in episode 5A. Prepare your detailed testimony for court. Use this time wisely. You have to work 10 to 30 hours a week on top of your day job. Focus on the best interests of your child and how your proposed parenting schedule meets the needs of your kid. And type out your testimony, read it several times, and memorize it for when you finally give it in court. If you haven't prepared at least 10 hours of testimony, then you're probably not ready for court. After each occasion the mother testifies, quickly get the court transcripts in between court dates. Prepare new testimony to counter any new false statements or allegations in her testimony. Use her lying to your advantage. Prepare for the forensic evaluation like it's a job interview. Show the forensic evaluator that you're the parent that's better suited to meet the needs of your child. Don't go into that meeting unprepared and then hope for a good outcome. You'll meet this person for 5 to 10 hours, so make sure you have enough to talk about. And strategically plan for the stories you want to share with this person. Treat this like a miniature trial in front of a psychologist instead of a judge. Use this time to be the best parent you can be to your children. If you want the job of primary or 50-50 parent, then play the role of a dedicated parent by prioritizing the needs of your child in everything you do. And yes, it's extremely degrading when you already did this before your divorce, but the court acts like you're a second-class citizen. If the mom is crazy, it gives her more time to do crazy things during this process. If she's still doing crazy things, it's now in front of the judge, and you should keep bringing these up at your 10-minute monthly conferences. Some examples of these things might be not providing for your child's medical needs, endangering the welfare of the kids, using child protective services or police to continue making false allegations, violating the court order and preventing dad from having his parenting time, insulting the father in front of your child, not helping your child thrive educationally. If your kid is doing poorly in school, use that to demonstrate that your child would do better academically if he primarily lived with you. Not being able to co-parent or keep you informed of key issues with your child because she is too angry to speak to you after your divorce. You'll expose these behaviors as they happen during your 10-minute monthly court appearances. But you'll also package them together and talk about them in your direct testimony at trial. Why? First, because judges have thousands of cases, and they forget the facts of your case. Second, because the 10-minute court appearances are speed contests, and there's no time to think thoroughly about any issue. But when you're testifying, you have the microphone, and you have the time to clearly present the full circumstances of the mother's bad behaviors. As kids turn 12 or 13 years old, they start to get more of a voice concerning where they live. There are countless stories of children who prefer to live with their father because the mother is unstable or unfit. A trial can be expensive and stressful for the parents. Use that fact in mediation to get a settlement for 50-50 or primary custody. A long process gives you more time to mediate something you can live with. But don't mediate and give up equal or primary custody just because this process is too long or expensive. You'll pay for that decision in the long term. Stand your ground. Before I start talking about the disadvantages of a long custody trial, please like, subscribe, and share. Also, if you find this information helpful and you want to support this channel so I can make more videos, please donate via my YouTube channel's About page. You can donate via PayPal or Venmo. So let's get to the negatives that you need to work around. The more time she's a temporary custodial parent, the greater the risk that, at the end of trial, the judge will decide, oh well, since the mother has had custody during this 3-year period, we should just keep it the same because the kids are now used to it. And the judge might use that excuse even if it's in the worst interests of the child. So you have to shorten the timeline. Your goal is to have at least 50-50 custody after the first initial appearance in court, as I discussed in episode 6C. Generally, after that first hearing date, judges often refuse to change custody orders in any significant way until there's an actual trial. Sometimes, judges will make small changes to a parenting order, maybe a couple of days per month, but don't expect that they'll completely change the primary custodial parent before trial happens, unless there's a major incident justifying that. In temporary orders versus final orders of custody, in general, when the judge issues a temporary order, you can't appeal it. You can't appeal temporary orders that are still waiting for a full trial. You can only appeal final orders of custody that are issued after a trial. So you're stuck with temporary orders, even if they're in the worst interests of your child. Make sure you research your state's laws to understand your rights to challenge any temporary orders. If you can't change them, then you have to just persevere until the end of a fact-finding trial. A custody trial is stressful for both parents, and maybe more so for the non-custodial father who has been unjustly removed for most of his kid's life. You're likely to have extreme feelings of anxiety, fear, depression, anger, and hopelessness. You're not alone. Focus on the idea that family court is designed to repeatedly rule against the father on issue after issue and make him think he has no rights, so that he's pushed into not even fighting for custody. And then the court can get its default scenario where the mother gets custody and the dad becomes a child support ATM machine. They want you to be demoralized. Stand your ground. I use the energy from these emotions to push me to work 10 to 30 hours a week, non-stop, preparing my custody case to save my son. I know it's hard, but use that emotional energy in a constructive way. In a multi-year trial, the other side can bully you into settling for an agreement that's not in the child's best interests. I think the standard bully tactic used by mothers is, you have parenting time 6 days a month. I can give you 8 or 9 days a month right now, and you can forever be the non-custodial parent. Or you can wait another 2 years for the custody trial to end, pay thousands of dollars to a lawyer, and then still have a judge give me custody. Normally, the judge gives the mother that negotiating leverage. Many dads fall for this bullying tactic. Think twice about giving in, and instead, fight for the parenting arrangement that's best for your kid. Also, as long as the mother has temporary custody and the judge keeps reinforcing that, it becomes harder for you during mediation because the mother is anchored in the belief that the judge is going to rubber stamp whatever she wants. But you have to stand your ground. A long trial means that you have more court appearances to keep paying your lawyer if you have one, as well as the cost of more transcripts. That will drain you financially so that you're forced to settle. Check out episodes 3C and 3D to get ideas on how to save money on court costs and legal fees. The longer the temporary custody order is in place, the longer you'll have to pay more child support. Child support is an extremely oppressive burden on most dads, and transferring all this money to the mother makes it difficult for you to pay for the lawyers or forensic evaluators needed for a trial. Plan ahead financially so you're not prevented from having that trial to determine the true best interests of your kids. The longer you're the non-custodial parent and paying child support, the more time there is for something bad to happen, such as losing your job. If you can't pay child support, the state agency will come after you like it's the end of the world. And if they arrest you for not paying support while you're still litigating custody, there's a great risk the judge will look at you like a deadbeat, even if the reality is that the child support orders are overly oppressive. They don't care. With a long wait until trial, you risk that witnesses will forget what happened between you and the mother, so their testimony becomes less useful. These events are central to your life right now, and you remember it all. But it's not the same for many witnesses. They move on with their lives. So throughout the trial process, meet your witnesses repeatedly, ask them what they remember, and ask them to write it down so they don't forget. A longer trial process creates more opportunities for there to be any sort of accident during your parenting time, where the mother will call Child Protective Services against you. If that happens, use those occasions to convince the social worker that not only are you not a danger to your children, but you're actually a great dad. In other words, don't just prevent a negative report about you, but also create a positive report about you, because the judge will see this. Now let's talk about some additional strategic and tactical moves beyond what I've already discussed. Try to mediate early in the process so that if the mother does not agree to give you at least 50-50 custody, tell the judge, "Your Honor, we've been at this for months and we can either mediate or we can proceed with trial. Trial will be expensive and we're using money that could be used for a children's college education. And we're using valuable court time that can be used for other cases. I won't discuss anything said in our confidential mediation. Therefore, I'm asking the court to issue a temporary order of 50-50 custody at this point so we can reasonably mediate something that's in the best interests of our child. You can imagine how difficult it is to negotiate a reasonable settlement when one party is anchored in the belief that a temporary custody order gives them the ultimate right to be the final custodial parent, even when we haven't had a fact-finding trial to determine the actual best interests of our child." This is a polite way of telling the judge that she's totally screwing up mediation because she keeps rubber stamping the mother for temporary custody for no legitimate reason. The time to pursue custody is right now. Some people fall for the mistake that they can give up custody now and then fight for custody in a few years when they're better prepared for it. However, the way the law generally works is that if both parents agree out of court and the court accepts it, then it's assumed that decision is in the best interest of the child. If you come back in 3 years and say, "I should have custody," then the question becomes, what change of circumstances have happened since the last settlement in court? And at that point, you can't talk about things that happened before that settlement, such as the mother's violence, neglect, or other bad behaviors, because all of that was already assumed into the last decision you agreed to. So in a few years, if you want custody, you have to prove a significant change in circumstances from the date of the custody order. And that is not an easy burden. So the time to fight for custody is right now. Try to accelerate all of the court processes that have to take place. For example, look at my episode 6D to see the different processes and how long they took. Immediately start asking about the trial process and what steps are involved to get through a speedy trial. On day 1, ask if you need forensics and start the process of submitting names of psychologists on the first or second week instead of waiting 6 months. Get the forensic report done in 3 months or so. Don't let the judge and lawyers just talk about the possibility of a trial. Have them schedule trial dates as soon as possible, and try to schedule 5 or 10 of them at the beginning, telling the judge there's a lot of evidence to discuss the best interests of the child. Get Child Protective Services evaluations done as quickly as possible. If there are criminal charges pending, proactively work with a district attorney to get them dismissed as fast as possible or have a quick trial to get acquitted. But don't sacrifice quality in the criminal matter. Don't confess to a crime you didn't commit just to get it over with. And don't sacrifice time if you need that time to gather evidence of your innocence. Doing those things wrong will cost you later. The mother or her lawyer might say, "No, I need time to prepare for this custody trial." You should assume this is just a stalling tactic to keep the mother as temporary primary custodial parent as long as possible. So you can say, "No, your strategy is transparent. You're making false allegations of domestic violence. You'll testify to some fraudulent claims, and you'll try to show that she's somehow a victim. You can prepare that in a month. Preparing for the forensic evaluation is a mini trial in itself. So if you're ready for forensics, then you're ready for trial. I'm the one who needs more time to overcome the current presumption that the mother should be the primary custodial parent. But I'm waiving that, so we can quickly get to trial and get a custody order in the best interests of our child instead of the best interests of the mother." Just be aware, this means you have to work harder and faster to prepare your case. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position. Also, if you find this information helpful and you want to support this channel so I can make more videos, please donate via my YouTube channel's About page. You can donate via PayPal or Venmo.